Okay, so welcome everybody. I'm sure we'll have a few more people join us shortly as well. We welcome back Advocate Idan Seger. He's going to be talking to us about what's going on with the judicial overhaul here in Israel. For those of you that were here back in January, he gave a very comprehensive explanation as to what was going on, and we thought that 7 months later, now that the first, I guess, major piece of legislation has gone through, I wanted to invite Idan back just to talk about what that legislation means, how it affects all of us potentially, and what it means about where Israel is going right now. So let me just hand over to Idan. As I mentioned just before, if you could all keep yourselves on mute, that'd be wonderful. Thank you very much. We will have time for questions at the end. So if you do have any questions that you'd like to ask Idan about, then please hold them to the end, and we'll try and go through those as we can. Okay, wonderful, excellent. So Idan, hello.
Hello. It's very nice to be here. And nice to meet everyone. My name is Idan Seger, as Roy mentioned. I'm a lawyer specializing in public law. I did my internship at the Supreme Court and at the State Attorney's Office. And Roy set a number of questions for us to discuss as part of this meeting. So I will begin by answering all of those questions. And afterwards, if anyone has any more questions, they're more than welcome to ask. So the first question will be, what are the repercussions of the passing of the Reasonableness Law that passed last week? And are there other ways that the court can override governmental stupidity, as Roy phrased it? So it is important to understand that reasonableness is a judicial cause in administrative law and not constitutional law. That is, it is a cause for judicial review of the actions of the government and not of the legislators. And in accordance with the reasonableness cause, the court examines the various considerations that a certain minister in the government considered and asks, for example, if that minister gave too much weight to a political consideration and too little weight to other public interests. And a striking example is a decision that was made for decades by the Minister of Defense, determined it is not possible to write personal notes on gravestones of fallen soldiers that are exceeding the official inscription of the IDF. And the court ruled that the Minister of Defense gave too little weight to the honor of the deceased and the wishes of the deceased family. And another famous case is the one in which the High Court ordered the Israeli government to protect children's classrooms in the Gaza Strip so that they would not be exposed to fire rockets from Gaza. The government preferred not to do this until the court's decision due to budgetary considerations. And the court decided that it is not reasonableness. Without the legal cause of reasonableness, it will be very difficult to prevent the dismissal of professional officials in the executive branch, including senior officials such as the legal advisor to the government, the state attorney, the chief of police, heads of security services, the governor of the Bank of Israel, and etc. Appointments and dismissals can be made while giving maximum weight to considerations of compatibility with the appointing minister, and meanwhile giving negligible weight to other important considerations such as the level of professionalism, independence, relevant experience, and public trust in the appointment. And that enhancement of the government's ability to fire professional appointments, such as the legal advisors to the government and the state attorney, can also affect the perception of the independence of those officials. At the level of international criminal law, if the law enforcement system in Israel is perceived as less independent, because those people can be fired, and the legal cause that protected the ability of the government to fire them is gone now. So if the law enforcement system in Israel is perceived less independent, this might expose the IDF soldiers to legal proceedings at Hague. Public international law works according to a principle called complementary. And it means that the ICC, the International Criminal Court, has secondary jurisdiction after national courts and can only act in a given situation if the relevant state is unwilling or unable to prosecute the crimes within its jurisdiction. And the less independent executive branch in Israel, or enforcement system, to be more specific in Israel, could be concluded as a system that is unable to prosecute crimes, and therefore exposing the IDF soldiers to the ICC jurisdiction. And without the reasonableness legal cause, it will also be very difficult to interfere in the decisions that a transitional government makes in the time before going to elections in Israel. The reasonableness was the main, if not only, legal cause that restrained transitional governments here in Israel from carrying out economic and political hijacks or making appointments that would block the next government. So without that legal cause, we're also dealing with transitional governments that can do whatever they want, basically. And it is true that the court has other grounds and tools to deal with decisions, bad decisions of government ministers. For example, a decision can be invalidated by the court if it was made without authorization by law, or if it was based on extraneous considerations, or if it disproportionately infringes on constitutional rights. But as I said earlier, there are quite a few cases in which the legal cause of reasonableness protected public interests, and it disappears and could greatly harm the rule of law and the separation of powers in Israel in many cases. So that was the first question. Second one was if our legal petition, which I will talk about now, against this law that passed last week, what it is about and why the court chose to wait until September to deal with it. So I will start by saying that I represent, together with my spouse and his legal partner, about 45 petitioners, among them senior businessmen, senior reserve IDF officers, and former Knesset members. We filed a petition with the Supreme Court shortly after the Reasonableness Law passed last week, and several other petitions were also filed after. All of them will be heard on September 12 in front of an historic panel of 15 justices. It's all the justices in Israel. That never happened before. The Reasonableness Law is a basic law. And for those of you who were not present in my previous lecture and still don't know that, basic laws are more or less the chapters of the Constitution of the State of Israel. When the Israeli state was established, its founding fathers were unable to establish a constitution, a full constitution, and they decided that the Knesset could establish the constitution chapter by chapter through basic laws, until at the end, all of those basic laws would be combined together and become our constitution. The problem is that unlike the Constitution of the United States or any other Western democracy, the basic laws in Israel can be changed by a simple majority of the Knesset, and the Knesset is controlled by the government. So that means that in practice, the government can change the constitution in its favor whenever it pleases to do that. However, that power wasn't used by our different governments for many decades because both sides of the political aisle had respect to the Zionist project and its main principle of liberal democracy. And throughout the years, changes in the basic laws, certainly substantial changes as the one that we're talking about now, were passed only with broad consensus. For example, the composition of the committee for selection of judges, which the current Netanyahu's government wants to change, was determined by a broad consensus of the coalition and the opposition in 1953. Menachem Begin, the chairman of the Likud movement and the strong defender of liberal democracy as well, was back then chairman of the opposition. But recently, this habit has been undermined, and until we reach the peak of it, of this misuse of basic laws, in the last few months, Israel's governments, benefiting from a coalition majority in the Knesset, began to change our basic laws in an increasing manner. And again, as I said earlier, unlike an amendment to the American Constitution, for example, which enjoys at least a 2/3 majority in both houses and a 75% majority in the state legislature, an amendment to the basic laws relies only on the simple majority of the Knesset that can be achieved in regular elections here. So this has, of course, forced our Supreme Court to develop doctrines to review such changes, and it did so in the past 5 years. One such doctrine is the misuse of the power to establish a constitution. And in accordance with this doctrine, the court examines whether the provision that the Knesset chose to insert into a basic law is a general and stable one, and one that is also related to a regular content that we used to see in constitutions. Or if it is just a provision that was inserted into a basic law due to a specific need of the government and to serve the government's interests, short-term interests. For example, in the basic laws dealing with the government and the state budget, it is established that a government which has not approved a budget by a certain date will dissolve, and Israel will go to election in that case. But at the end of Netanyahu and Gantz unity government a few years ago, the government decided to change this basic law so that they will have more time, an extension to pass the budget. And our Supreme Court ruled in a majority opinion that this is an abuse of the power to change the basic laws, which need to be struck down. By the time the ruling was issued, the ruling of the Supreme Court, it is no longer had any operative meaning because the government has disintegrated anyway, but the Supreme Court had a very strong opinion about the way the government used its ability to change basic laws and to change the democratic rules while playing. The second doctrine of interference with basic laws is the doctrine of the unconstitutional constitutional amendment. And according to this doctrine, members of the Knesset do not have the authority to abolish or harm very badly the minimal democratic or Jewish features of the state of Israel. In terms of democratic features, it is the separation of powers, independence of judiciary, human rights, free elections, and the rule of law. And this doctrine has never yet been fully accepted by the Supreme Court. It's a much more fresh doctrine. The current Chief Justice, Esther Chayut, referred to it in her judgment regarding the Basic Law of the Nationality in 2020. That basic law established that Israel is the nation state of the Jewish people and did not include reference to the value of equality. And that basic law was not invalidated because our Supreme Court ruled that it does not cancel the value of equality, and it is possible to reconcile this new basic law with all other characteristics of the state of Israel as a liberal democracy. It is difficult to estimate how the Supreme Court will rule in the hearing that will be held in September. In my estimation, there are considerable chances that it will determine that the immediate application of the cancellation of the reasonableness clause is an abuse of the authority to establish a constitution. Because if you think about it, the government is actually removing judicial review from itself in real time. Even if it is a very democratic or a very proper amendment to our constitution, in a normal country, it should apply only from the next government and not on the own government who enacted it. It is also important for me to emphasize that cases in the Supreme Court usually being heard for years. And the fact that the petitions were submitted last week and that in about 5 weeks there will be a hearing before an historic panel of 15 justices indicates that the court sees the current petitions as very important. It is not slow pace, it's very, very fast pace. And the court is also practically obliged to discuss those petitions and decide them very quickly because 2 justices, Chief Justice Esther Chayut and Justice Anat Baron, will be retired in October 2023. So they have only 3 months after retirement to write those decisions. And another thing I would like to address is Prime Minister Netanyahu's lack of commitment to respect the Supreme Court ruling on this matter. Since this is an amendment of a basic law that deprives the court of one of their authorities, one of their legal cause, those who are supposed to respect the ruling of the Supreme Court are the courts themselves, and they will respect the Supreme Court ruling. So the government doesn't need to do anything in order to respect that ruling. And apart from that, it shouldn't surprise anyone that Prime Minister Netanyahu says he won't respect the Supreme Court ruling, because in fact, he is not respecting the Supreme Court ruling for several months now. Our Supreme Court, when he discussed the matter of Netanyahu's tenure as an accused of bribery and breach of trust, allowed him to serve as prime minister only under a conflict of interest arrangement that would prevent him from engaging in legal reforms. And what Netanyahu has been doing in the recent months is engaging in legal reforms almost every spare moment of his time. So he is very it's very clear that it's very clear that he is not doing what the Supreme Court already ruled on his behalf. So the current statements shouldn't surprise anyone. Another question that Roy asked me was if the protest had any effect on things. And on that matter, I want to say that yes, the protest and the large demonstration had a great effect. We should remember that in January 2023, this January, when the protest just started and we had our previous conversation, the plan of the Justice Minister, Yariv Levin, was very dramatic and immediate, and he wanted to change the composition of the Committee for Selection of Judges and make it one that is controlled by the coalition. And he wanted to determine that the Supreme Court can hardly intervene in legislation that violates human rights, and that even if it does intervene, the Knesset can override it through the coalition majority. And he had in mind many other anti-democratic changes in the legal system of Israel, which would have turned Israel into an undemocratic state. And all of those changes were stopped, thanks to the protests in the streets, which led to international pressure and pressure from the army officers and business sector. So yes, the demonstrations had a very, very great effect. And they may not have stopped the current legislation regarding the reasonableness clause, but they made it very clear that a very large portion of the people are not pleased with the constitutional amendment that is being made now. And another question I was asked was if there any possibility for the Likud and Yesh Atid and Benny Gantz to come together in a unity government. So it's more a political thing than a legal thing, but I don't think there is a possibility for a unity government. In my opinion, Netanyahu has no interest in that because he's looking for ways to evade his trial, and the supposed partners from the opposition, Lapid and Gantz, will never provide him with these goods. Only when Netanyahu feels that all the ways to escape from his trial are blocked, I think he will be able to really consider the possibility of adding elements from the opposition to the government. But at least for now, the opposition denies this possibility as well. So Lapid, who heads the largest opposition party these days with 24 seats, completely ruled out this possibility in the last days. He also set a condition for the talks on the judicial overhaul, other parts of it. And his condition was that the legislation that will not allow the government to move forward on its own will be set into a basic law. So the government could not do that, could not go on its own like they did now for the next year and a half. That's a precondition that Lapid is now giving to the government in order to get back in the room. And the last question that Roy asked me was, what can each of you each of us do to contribute to the situation? So it's important to talk about things. I hope that I have equipped you in the last 20 minutes with, and in the coming minutes that we'll talk, with information and with knowledge about the topics that are now being talked. And it's important that you will pass on this information to influential people you know, but also to all of the regular people you are surrounded. And those of you who can go out and demonstrate should do that. And if anyone can also help to put up some more pressure on various political or commercial players, please do so as well, and explain them the delicate situation our democracy is currently facing. And on this note, I think I'm done with what I have prepared to say, and you can ask me questions about the things that I talked about or other questions that are in your mind.
Wonderful. Thank you very much for that, Idan. So I just wanted to ask people, do you have any questions, please, that you'd like to pose to Idan? Stephanie has raised her hand. Hello.
Can you hear me? Yeah.
Yes.
So my first question is, as you mentioned, the full court is going to be hearing this case, and I was wondering what you think that might telegraph, what that might communicate about what their thinking is, what they might do with this, what they might decide. Does it, but the fact that they've chosen to have the full court, does it indicate a direction they might be going in? And I might just add to that, could it be that they could redefine the standard for reasonableness, or let me rephrase that. Could they use the reasonableness standard to require a broad consensus on creating basic law? Could they actually do that?
So I will start with the first question. I believe that the fact that Justice Chayut decided to hear these cases in front of a large panel, an historic panel of 15 justices, indicates that the court will intervene in a certain way. I don't know what that way will be exactly. And I think that Justice Chayut doesn't know as well, because it depends on the majority of the justices' decision. I think that she wanted it to be very clear that the decision is made by a broad consensus of the justices, because if we're talking about the way that basic laws should be passed, then when they are being under judicial criticism, we might also ask that it will be with broad consensus, that they will be struck down or changed in their interpretation by the justices. The way the court will deal with it differs, in my opinion, to 4 different ways. One is to declare that this basic law should be struck down, which is the hardest thing to do, in my opinion. Second is to declare it will be applied only from the next Knesset. And in this way, the conflict of interest and the very particular interest that led to this legislation would be at least a bit softened. And the third thing they can do is to make an interpretation. This deals with the second question you asked about what does it mean that the court doesn't have the ability now to discuss and give decisions about the reasonableness of the decisions of ministers and the government as a whole. And in this kind of interpretation, they can say that a principle that has been very common in administrative law, that says basically that the government is right until someone proves it wrong, will not be enacted from now on, because if the court doesn't have the ability to check the reasonableness, then it should be stated from the first place that the decision might be wrong, and then the government has the burden to show why it's not. That is one interpretation they can do that will make the change in the basic law more easy to swallow. And they have many other options of, we will call it interpretation that will save the law, but will give it a minimum effect that will hurt the democracy and the separation of power and the rule of law. And the fourth option is to not intervene at all, to just say that this law means exactly what it means. We don't have any business with it. We don't want to touch it. And I believe that this option is, I give it 10%, even 5. Like, never going to happen, in my opinion. It's going to be one of those 3 options that I talked about earlier. I believe so, at least.
Wonderful. Let's hope. Thank you very much for that question, Stephanie. Next, we have Jude. Hello, Jude. Oops, sorry, Jude. I muted you as you were unmuting yourself.
That's all right. I have so many questions, but I want to take it a little bit in a slightly different direction. I'm a teacher in high school. There's a lot of fear-mongering around, where are you getting actual information about which laws are being passed? Because the amount of fear-mongering of like, they're recording your classes now, you can't speak freely. Like, the problem is, I don't know, like, this is step 1. Okay, what does that mean in actuality? Like, I don't actually think this affects our classroom, but I have like no real idea into like what steps would actually, like, I don't know, it just feels like such a mess.
It is a mess.
But I'm trying to understand, like, what is that law? Does that have ramifications? Because everyone's like, free speech is gone. All of this is gone. We're in a dictatorship. And I'm like, I can't listen to the news because it doesn't actually help me with like what I need to know for in September. And like, if my day-to-day life needs to change in any sort of way, people are like, they're going to put Shabak in your classroom. I'm like, I don't know. Can I just like get real information?
So, okay. First of all, you can breathe. All of those scary things that we're talking about and imagine in dictatorship will not happen tomorrow or in the next month. But we're in a slow pace, or slow or fast, depends on the month, going to a very last democratic state that the government has a massive power that is not criticized in this state that they're trying to create. But currently, we're not facing this kind of state in the very near future, and the change in the basic law that has been enacted now only make it possible for ministers to make decisions that are arbitrary, that are not well integrated between different considerations, without the court being able to tackle those decisions once a petition is being filed against them, on the reasonableness of those decisions. But the court has, as I said earlier, other causes, legal causes that it can work with. For example, if the freedom of speech is being cancelled in a way, in a certain decision, or not being properly dealt with, this public interest in this specific human right is not being properly dealt with, then the court has the proportionality test, another legal cause that he can refer to in order to save those rights for people. So you don't need to be afraid in the short term. We're in a long battle here. We're fighting for not just for those changes not to be enacted, but also for the possibility of those changes to be enacted in the future to be abolished. We want Israel to be a much more stronger democracy, and this is a long fight that we're going to fight for many years now. But rest assured, you can go into your class in September and nothing bad will happen. I believe so. I truly believe so. And let's see what the court will decide after September.
Wonderful. Thank you very much for that. Thanks for your question, Jude. Next, we have David.
You're mute, David.
Yeah, David, can you unmute?
Yeah, okay, can you hear me now? Yeah.
We
Yes.
can.
Yeah, this is sort of tangential, but it'll affect us all. Do you think there's any danger in the future of gay rights being withdrawn by this government?
Sure, there is a danger, and we see that even these days there are very harsh opinions that the ministers show for the LGBTQ community. Just yesterday or 2 days ago, we were announced that Sar Revacha, the welfare minister, told Bagatz that gay couples, in his opinion, don't have a right to adopt children. And tomorrow there will be a hearing on that topic in the Supreme Court. And of course, as long as they will get more power, the threat to the liberal community and the gay community in it is much more broader and threatening. But as I said earlier about freedom of speech, gay rights are, most of them can be considered also as constitutional rights: the right to have a family, the right to respect, to live your life as the way you wanted to live them. So on all of those occasions, you can still go to the court if a government decision or a specific minister decision hurts your right, and you have other legal causes at this stage that can protect you. But if the government will succeed in taking over the committee of selection of judges, and if it will succeed in passing an override clause that can enable the Knesset to do horrible things without any judicial review on them, then it's a huge threat for the LGBTQ community, and I don't think I will live in this kind of state if those changes will pass. So we're fighting on all of our tools to deny it, to not let it happen.
Thank you.
Wonderful, thank you. Are there any other questions, please?
I have a question, if I can.
Sure, Mike.
I'm not quite sure how to ask it, but it seems like the government doesn't really care about the courts or the committee in the Knesset, and it's how will it actually affect them? It seems like Bibi does what he wants, the Levine does what he wants. I'm not quite sure what benefit going to court will give us.
So in case that there will be an imperative decision of the Supreme Court, let's say saying that Netanyahu is no longer in a capacity to be prime minister. This is a very radical decision. I don't know if they will make it, but let's say they will. Or let's go even in a smaller portion and say that they will decide that Levine is obliged to convene the committee for selection of judges that he's preventing from being together since the establishment of this government, because he doesn't like the current composition of it. So let's say that Levine doesn't oblige to that and don't do that, then the court has many sort of tools to make it happen. They can decide that another relevant member of the committee will be the one that will convene the committee, not the justice minister. If the justice minister doesn't do that, they can also, in a very radical situation, impose the sanctions on Levine. And those can be monetary sanctions and also sanctions of sending him to prison. And the security agencies in Israel are all obliged to the principles of democracy and rule of law. So, and we hear in the past few weeks and months that those who stands in the head of those organizations, Shabak, Mossad, Tzal, sort of, say that they will obey the rule of law and the court's ruling. In so many words, they say it. So I think we can be at this time be optimistic that if some decision with an operative meaning, it will not be dignified by the government, then the state of Israel as a whole will have the power to enforce it on the government.
Thanks.
Excellent. We have another question from Stephanie. I just wanted to ask before we go there. A lot of MKs have been saying stuff, and it's being reported in the newspapers about what they want to happen. And you know, it reminds me of the 4 years where Trump was in charge of the US, and every morning I'd wake up and I'd read the headlines. It's like, oh, what has he said today? How much of that actually matters? Because, you know, a lot of it, the newspapers are there. They're there to sell newspapers. I mean, that's their main goal. And if they can have a shocking headline, then they'll print it. So how much of a concern is it what some of these extremist MKs are saying? You know, what can we ignore? And, you know, what do you see as being, you know, once the Knesset returns in September, what are the major issues that we're going to see coming up?
So the Knesset will convene again on the middle of October after the holidays. And the first thing they will want to enact is a new recruiting law, because the current law or the previous law that allowed Hasidics not to join the army had been struck down. And there is no law these days that permits ultra-Orthodox Jews not to participate in military service. And the government is basically not acting by law these days, but no one will actually enforce that, because that will be starting a war. But I do hear some people making fun with, not so fun, but making some ideas of approaching the court with a demand not to recruit secular Jews and give them the opportunity not to be drafted, because the government is doing that to a large section of the population. So the principle of equality obliges it to be broad, and this option should be given to all the population. So this will be the law that will be in their main concern, because the ultra-Orthodox in the coalition has their eyes on that goal. They can do that by law or by a basic law that says that learning the Torah is as much as important as serving the army. They started to say that this is something that they want to enact in the next Moshav of the Knesset. And it will be interesting to see how much of the judicial overhaul will be dominant in this Knesset, because they're already in a very, very inconvenient place from the eyes of the public, even their voters, the Likud voters, dealing with this kind of law that's giving the Hasidic an option not to serve. So about your first part of the question, I would say that we always need to listen to what those MKs say and respond, even if sometimes it seems just madness, because we don't want the lies being spread, and we don't want people to start believing those things just because someone says it over and over and over, and no one says anything in return, because people think, well, I know that, like I know that the Supreme Court has the ability to strike down a basic law, and it's only reasonable to believe it has this ability because it's just a law that the coalition decided to call it a basic law. But if I won't say it to people and I won't explain it, then after hearing many MKs say it day and night, they will believe that the Supreme Court has no ability to do that and he's overreaching his powers. So it's important to talk about all those things and not leave those messages undealt with.
Wonderful, thank you for that. And we have a question from Stephanie.
Yeah, hi, thanks again. It's funny because the question I wanted to ask when I raised my hand was to ask about the constitutional moment that people keep talking about. But I kind of want to ask a follow-up question on the proposal of creating Torah study as an alternative to IDF service, and what I thought was could the court intervene in something like that and say, well, for equality standpoint, from an equality standpoint, if we do that, we have to make that available to everyone. And then you say, well, you can't, not everyone can do that. So you have to say, well, a certain percentage of people who are drafted, can go into Torah study. And then everyone else has to go into doing, other IDF service. That way, kind of making it equal for everyone. That's kind of a loose thread that was running around in my head there. But my real question was, is there any potential for taking this, taking this as a constitutional moment and really going there, all of this is generated because there's a lack of a written constitution, and to finally address that.
Yeah, I believe that after this government will pass in this way or another, and I hope with lesser damage than many of the damages they've already been doing. I think that the next stage will be, at the minimum, deciding that a basic law can be enacted only by a majority of 80 members of the Knesset, and can be taken into effect only in the next Knesset, and not in the Knesset that enacted it. And also, this is the minimum. I believe we need to do many other things in order to protect liberal rights here in Israel. I don't know if we have partners to do that in a broad consensus. So there are a lot of talking about separation in this way or another to different, not states, but sections with stronger municipality abilities and authorities. So this is another direction we're thinking about. It's hard to say how will history lead us, but I believe that if we go out of this crisis, then the first thing that need to be addressed is the very easy way basic laws can be changed, because given a very strict rule about how we change basic laws, then we do have a constitution. We just need to pack it together. We have a lot of basic laws, very elaborated, that talks about the government, the Knesset, the president, which is a symbolic figure in Israel, but still has a basic law of its own. Even the IDF has a basic law. And we have, of course, we have our basic law of human rights and dignity. And we have basic laws that deals with the budget. So we have a lot of constitutional instructions. We just need to make them not so easy to tamper with. And if we do that, then we're already in a much more safe zone. But I do believe that in the long term, people will want to live more freely in Israel. People will want to know that they can go on the train that is now being built in the center of Israel on Saturdays as well. And they want to do many things on Saturday, and they want to eat things in a free way. So they do want to have sort of a Jewish sphere, but they don't want it to be they want it to be complementary and not something that someone is enforcing on them. So I guess that in order to go that road, we will need some kind of separation and maintaining the municipalities as bodies that have more authority and can decide and who can marry who. And who, this is actually one of the basic things I don't understand. Why didn't it start with this? And the fact that we cannot marry who we want to, and we need to go abroad to do that. So I hope I answered.
Yeah,
thank you.
Thank you.
One thing that I just wanted to pick up on was your comment that, you know, when we come out of this, or if we come out of this the other side, I think it's important to remember that this isn't set in stone, that there's a lot of things that still can be done. There's, you know, oh, hold on, I'm echoing. We're not definitely heading down the road to, you know, away from democracy towards a theocracy. There's a lot of things. And from what I'm hearing you saying, there's the courts, you know, this isn't, I think the media has put forward this particular law and the override law that failed, thankfully. There are still ways that future laws that the government decides to put through can be struck down. So we don't have the checks and balances that, say, the UK or the US have, but there are still checks and balances in place. So
at this moment, yes, sure. At this moment, we do. We just need to maintain them and to make it harder to change the democratic rules later on.
And if I think I asked you this last in January. Again, pure prediction. Do you see this particular coalition lasting the full term, or do you think it's going to collapse? Because there have been many times, almost every week it seems, that people are threatening to leave it. Is there a chance that could actually happen? And has your answer changed since last time?
Actually, many things happened during those past months, so I'm not sure what I answered back then, but I believe that they will not survive a full tenure because there are many obstacles in their way and many different interests. Let's say if we're talking about someone like Ben Gvir, he has a very strong interest to go to the next elections not from the government and to be a far-right representative in the Knesset that attacks the government from the right. And the question is, when will he decide to do that, to go and leave his office? And I believe that because he's showing very poor abilities in preventing crime and terror at his current position, he might do this quite soon. So he can always blame someone else and say that he didn't have a lot of time and the legal advisors blocked him and the protesters have blocked him, you know, and blame anyone and make people fool enough to vote for him next time.
Yeah, the reaction at Jerusalem Pride, where he decided to walk down the road adjacent to the park, was wonderful. I managed to catch it on camera. People were, we were all screaming at him. Boucha. It was quite a nice moment. Wonderful. Okay. Does anyone else have any questions before we wrap up? Oh, there was a question here about the override law. So that was a law that failed to pass, thankfully. I think if I remember correctly, 4 Likud MKs voted against it, preventing it from passing.
They did not voted on it in the Knesset. In order to pass a law, you need to go with 3 calls, and it only passed 1.
That's right. Yeah.
They just decided to leave it there, and also Kohelet, which is a very strong engine of this judicial overhaul, stated in many cases that they do not think the override clause is a smart move. And it was also perceived in the international media as a very undemocratic rule. So they decided to leave it for now. I don't know for how long time, but it doesn't seem like they will pass it through in the coming months.
Okay, but you think there's a chance that it may return at some point? They might try it again.
Sure.
Who knows? Yeah.
Who knows? No one can actually know.
Wonderful. Okay. Lovely. Are there any questions? Any other questions? Nice one. So I just wanted to just repeat something you said earlier about the importance of the protests. I have to admit, I started off very motivated back in January, February, and then I kind of lost a little bit of hope about what was happening. But with the law passing last Monday, I felt personally a renewed motivation to get out there, and the atmosphere on Monday night was electric. And the protests on Saturday night in Tel Aviv and around the rest of the country was I think possibly bigger than any of the protests that have been so far. So I just wanted to say to everyone, if you haven't, or even if you have been protesting, please continue to do so, because the more people there are on the streets every Saturday night and all the others in between, the stronger the voice, and hopefully the more, at the very least, the more delays that we can cause. You know, the fact that they've only really managed to pass one major piece of legislation in the last 7 months is impressive, considering they have majority, and that's all they need is a majority. So the protests are definitely having an impact. So please get out there.
I might also say that it's not a major legislation, in their opinion. It's the very least important factor of the judicial overhaul, in their opinion. When they presented the judicial overhaul in January, it was the last paragraph. So we did a lot in those 7 months, and we can do much more. And tomorrow there is demonstrations from Rothschild to the district court. And I believe that from the district court, it's also passing through to Kaplan. So everyone also invited.
Yeah, that's at 7 o'clock, I think, tomorrow night, Wednesday night.
I believe so. I can check it in my phone.
Yeah. Okay, wonderful. Fantastic. So just wanted to wrap up, say thank you very much, Idan, for doing this again. I would like to say I would invite you back again, but I'm really hoping that we won't have to. And that things may calm down.
Maybe we can talk about good things that we can do.
Maybe that would be lovely. Yeah. I'll order the balloons now. So thank you very much for coming and spending your time explaining it, and of course doing this in English for us as well, because